talked much about what I call ARTS, assisted reproduction technology, but that is another mechanism that is really gaining in popularity. In fact, it's probably going to eclipse adoption in the not too distant future, of how people create a legally recognized parent-child relationship. Basically what ARTS is it's a practice that involves extensive contract drafting and parentage determinations, because you need, ultimately, just like with adoption or just like with third-party custody, the ultimate goal in these cases is creating a legally recognized parent-child relationship. With ARTS, instead of referring to them as adoptive parents, we refer to them as intended parents, because they're trying to create a legally recognized parent-child relationship, typically with a child who is completely or in part their own genetic makeup. So where these ARTS cases will come up is you've got let's just keep it simple again, with a heterosexual couple that can't, because of fertility issues, can't conceive or carry a child. They may or may not have viable genetic material. And so husband's sperm may be viable, wife might have an egg, but she can't carry the child. So what they will do, is medical technology has led all of this to be possible, is they will fertilize an embryo outside of the body. They don't have sexual intercourse, but they will get an embryo that will then be implanted into either the intended mother, if she could carry the child but she couldn't conceive, or more commonly they'll get a gestational carrier. So a third party that's going to carry this child for them, that's their genetic child. Well, you can just imagine the legal complications of that, because if you think back of how we decide parent-child relationships, it's typically who gives birth to the child is who goes on the birth certificate. We don't want her on the birth certificate. We want the intended mother on the birth certificate. So we draft these elaborate contracts. They may be between a gestational carrier and her husband and the intended parents, where they are agreeing they're going to do this medical process, and the carrier and husband are going to give up all rights. They're going to cooperate in the legal proceedings to get parentage established and get the intended parent's name on the birth certificate. We may also have contracts, because if they don't have genetic material that works for them, we have to deal with an egg donor, possibly a sperm donor, or an embryo donor. They have to sign a contract giving up all of their rights. And we, as the lawyers in this area, have to put all of this together. Now, what are the challenges facing us? Number one, it's incredibly complicated law. Most family law attorneys will not touch this area of law with a 10-foot pole, because it involves concepts of adoption, it involves concepts of contract drafting, which family law attorneys don't do a lot of. So it takes a very specialized attorney to do this. And most of the attorneys who have gotten into this area of law tend to come out of the adoption background, at least in the United States. Very few regular family law attorneys do. So it's a complication. In terms of the complication in it, is clients need to understand what's legally involved, and that's half a day of talking to a lawyer to understand it. And then they need to be prepared for the costs, which are substantial. A lot of insurance doesn't cover some of this. And then the legal complications, you may have, there's a contract drafting stage, and then we have to go into court and do the parentage piece, which is complicated. So those are the challenges. And I won't even tell you about the complications if it's an interstate or an international one of these, because then you've got layer upon layer of complication. Or same-sex couples, who they're doing a lot of this, because that's been their only way to create families for many years prior to the same-sex marriage.